This time last year, if you picked up a newspaper, there was a very good chance the front page would have been about Brexit. And whilst the global pandemic has changed that, Brexit has still come back to the fore, a reminder that other challenges we face are still here, COVID or no COVID. Well, we have a similar situation in the world of employment tax. 12 months ago, the hot topic of conversation was the extension into the private sector of the new IR35 rules that already apply in the public sector. The new rules require medium and large-sized businesses to review engagements they have with individuals operating through their own limited companies. The end client must consider whether the individual would have been an employee if they provided their services direct. And if they would, then the client must operate PAYE on payments it makes to the limited company. Lobbying from several groups prompted a limited review of the changes, but the government was set on introducing them from April 2020. Then COVID caused a major shift in priorities that meant they were postponed to April 2021. The rules haven't gone away though. The legislation has now passed into law, and the government clearly still sees changing the distinction between employment and other forms of engagement as a priority. When he introduced the COVID self-employed support scheme, the Chancellor said this support would mean that the national insurance advantages of not being an employee would, in his words, be harder to justify. So it's prudent to assume the new IR35 rules will come into effect as planned from April next year. And it's sensible for businesses to review their arrangements now with workers engaged through limited companies so they can make sure appropriate processes are in place.